Dennis O'Rourke.
Chairman, I first of all want to make some comments about the SOPs and then finish with some comments about clause 33A. So first turning to SOP 188 in the name of Honourable Amy Adams, New Zealand First will support this SOP. It does a couple of very simple things. Firstly, to replace the word notice with application in clause 16, and then another simple thing to extend from 1 to 2 years the period for periodic review of the Act. No problem with any of that. And also with the second of the three amendments that it makes, which is that a previous consistent statement of a witness will be admissible in evidence rather than the witness only being able to refer to it to refresh his or her memory. I think that's perfectly fine by us, and we're happy to support that SOP. The more substantial one I wanted to make comments on was number 195 in the name of Jan Logie, and I thought she mounted a very logical and compelling argument in favour of the thrust of that SOP, which would extend the use of the alternative ways to give evidence beyond the current limitation age of 18 years, so that all complainants of family and sexual violence could make use of that. We think that's actually a very good thing to do. And the main reason is that people who give evidence in those sorts of cases have had often traumatic experiences, and it is good for them, for those reasons, to be able to give evidence like video, for example, in those alternative ways. So in other words, it's the same rationale for young people who find giving evidence very difficult. For these people in those circumstances, it is just as difficult for them, and so why not extend that to people in those situations? So for that reason, New Zealand First will support that SOP. However, we're not going to support Jan Logie's SOP number 194. Well, 1 out of 2 isn't too bad, Jan. Anyway, the reason for that is we don't think that inserting the term intimidating after misleading is a good idea. And the reason simply is that I don't think the word intimidating is well enough understood, or is certain enough to be used in those in that context. So we prefer the word not be there, and will therefore not support that SOP. Now, the only other thing I need to do is something that I think deserves a comment, and that relates to new clause 33A, which inserts sections 119A and 119B into the Principal Act. And the reason I mention that is that the Select Committee heard a submission on access to video evidence, which I thought was quite compelling, and demonstrated what can happen to a person if we don't get the law right in these sorts of respects. And I refer in particular to access to video records of evidence outside criminal or family court cases, because some tribunals and similar statutory bodies have powers quite outside this legislation to call for and consider video evidence. But they aren't subject to the regime that is actually prescribed in regulations under the Principal Act, and injustices can flow from that. And there was an injustice to the person who made this particular submission. Now, under new clause 33A, the requirement that the police would be prohibited from releasing a video record of evidence to parties to proceedings outside criminal or family courts, unless the relevant body orders it, is, we think, most appropriate and would deal with the situation raised by the submitter, and will operate to avoid the sort of injustices that we heard occur to that particular person. And it's a very serious issue, because that person had suffered serious damage to his reputation and his ability to gain employment. So it's not as though it's a minor matter, it's a very serious matter. And I want to commend the Select Committee for listening to, understanding and doing something about that issue. We very much support it.
I call